Thank you, everyone, for joining us for this first in our series of the Americans with Disabilities Act, or ADA, Lunch and Learn webinars. And we are really happy that you joined us. My name is Jan Garrett. I am the Deputy Director of ADA Programs for the Pacific ADA Center and the Center on Disability. And I will be your host for this series, as well as your presenter for today. I am a white woman with gray hair, wearing gray glasses, and a tropical print dress, and my pronouns are she, her. So let's get started with the presentation today. Next slide. So the Pacific ADA Center is one of 10 national centers that are part of the ADA National Network. And on this slide is a map that shows the 10 regions of the ADA National Network, as well as the ADA National Network logo. And our mission of the Pacific ADA Center is to provide resources, training, and support to improve awareness and understanding of the rights and responsibilities under the ADA. And so we are, as I said, a member of the ADA National Network, and we are part of Region 9 here in California. Next slide. So what we provide is confidential information and resources on the ADA by phone and by email. We also provide training, virtual as well as in-person training. We provide conferences, 2 a year, 1 virtual and 1 in person. We also have resources and referrals that we can make that are relevant to the person's needs. And then we also have a website, which we will give you the information for at the end of the presentation for how to contact us, including our website. We do not provide advocacy services. We do not provide legal advice. We do not enforce any laws. And if you contact us by phone or email, we do not report your contact to any enforcement agency. So overall, we are here to provide information, materials, and resources on the Americans with Disabilities Act. And we are not here to provide advocacy or enforcement or to report anyone to an enforcement entity. Next slide. So let's start our session today with a little bit of information about disability and an overview of the ADA. Next slide. So why does it matter? Why does disability matter at all? The truth is that the chances are good that you or someone you know has a disability, and you may or may not know that. It is also likely that you will have a disability at some point in your life, even if you do not have one now. People with disabilities deserve an equal opportunity to participate in everything our society has to offer. And that's really the basis for the ADA as a law. And having a disability means that you may have legal protection from discrimination. Next slide. So, what are the statistics about disability? According to the U.S. Centers for Disease Control, 27%, or a little over 1 in 4 adults in the United States have some type of disability. And among people with significant disabilities, the percentage of disabilities that are non-apparent or quote unquote invisible has been estimated to be as high as 96%. So just because people have disabilities does not mean that you know that they have disabilities. A lot of people have non-obvious or non-apparent disability. In fact, the vast majority of people have non-apparent disabilities. Next slide. So what do we mean when we say apparent versus non-apparent disability? Or that would mean visible or invisible or obvious or non-obvious disability. So an apparent or an obvious disability could cause fear or pity. Like when people see somebody in a wheelchair like me, I'm somebody with a lived experience of disability. I use a wheelchair. And so sometimes people look at me and they have pity or even fear. Um, Also, people with apparent disabilities often face accessibility and or communication barriers. People with non-obvious or non-apparent disabilities, on the other hand, are not invisible to or hidden by those who experience them. People are not intentionally hiding their disabilities. Okay. And those folks with non apparent disabilities often face severe attitudinal barriers when others think that they're faking their disability. Next slide. So, how does disability intersect with other identities and other groups that people may have? So, in 2017, the Center for Disease Control, or CDC, found that 3 in 10, so that's 30% of American Indians and Alaskan Natives have a disability. For Black Americans, 1 in 4, so approximately 25%, have a disability. White Americans, 1 in 5, or approximately 20%, have a disability. For Native Hawaiian and Pacific Islander Americans and Latino Hispanic Americans, approximately 1 in 6, or 15%, have a disability. And then for Asian Americans, 1 in 10, or 10%, have a disability. In 2020, the Human Rights Campaign found that for LGBTQ plus Americans, 36% have a disability, so higher than all of these other statistics. And for transgender Americans, 52% have a disability, very high percentages. So people don't just have a disability identity, people come to the world with all their identities. And so we need to be sure that we are understanding that. Next slide. So, as we're talking about the ADA is a civil rights law. So, what does it mean to have disability civil rights? These are individual rights that are guaranteed and protected by the US Constitution and laws passed by Congress, like the Civil Rights Act of 1964 and the ADA. And there are many other examples of disability rights laws, as well as just general civil rights laws, like Title VI and Title VII are all civil rights laws. The Rehabilitation Act of 1973 is another disability civil rights law. So there are many examples, including the ADA, of civil rights laws. And disability rights laws protect people who meet the definition of disability from discrimination and give them an equal chance or an equal opportunity to participate in society. And we're going to talk about who meets the definition of disability under the ADA in a moment. Next slide. So the disability rights movement didn't begin with the ADA. Really, we knew we needed the disability rights movement for a long time. People with disabilities were facing really terrible discrimination and really did not have good lives with an equal opportunity to be in their communities forever, really. And so we needed the disability rights movement and the ADA in particular as a comprehensive civil rights law, because we had people who with disabilities who were institutionalized or were living in the back rooms of their houses. They were segregated in school. They weren't able to work. They were segregated in their community in general. Also, people with disabilities were sterilized. That was a movement called the eugenics movement. And so, they didn't want to create more people with disabilities. So they sterilized people with disabilities against their will in hospitals and institutions. Also, there was a terrible lack of accessibility in public buildings, any building, government or private buildings open to the public, and in transportation. And finally, there was really terrible employment discrimination. People with disabilities were never going to be able to get ahead or really be part of society because they weren't in the employment, they weren't in the workforce. And so the ADA really came along to change all of that. Next slide. And this is showing, let me go back one slide, I'm sorry. This is showing a photo of a major protest. And it does have a banner that someone is carrying that says, "Injustice anywhere is a threat to justice everywhere," which is a quote from Martin Luther King Jr. And these are very famous disability rights advocates in this photo, including Judy Heumann, who just passed away last year, and Justin Dart, who is one of the fathers of the ADA. Next slide. So what does the ADA consider to be a disability? The definition of disability under the ADA has 3 sections. The first section is a physical or mental impairment that substantially limits one or more major life activities. There are many major life activities, and in the box on the right, we have examples that are not an exclusive list, but they are examples of what can be considered major life activities that may be substantially limited for people. And these are things like walking, seeing, hearing, speaking, breathing, cognitive functioning, concentrating, normal cell growth, which would be something that would happen if you have cancer. Your cells are growing too fast. And many, many more things are considered major life activities. So the first section is a physical or mental impairment that substantially limits one or more major life activities. The second section is having a record or a history of such an impairment. So maybe you don't have the impairment anymore, but you have a history of it. And if someone uses that history to discriminate against you, that's considered to be a record of a disability, and you are covered by the ADA, even if you don't have the disability anymore. And then the third section of the definition of disability is being regarded as or assumed to have such an impairment. So a classic example of this is often given where somebody may have been burned and they have a lot of burn scars on their skin. And someone thinks that they have another disability or even a contagious condition. And they assume that they have that, even though what they have is burn scars. And so if they see that those burn scars and discriminate against you, assuming that you have some kind of contagious disease or condition, or they think you have some sort of disability, you may not have any disability at all, but they assume you do. And if they discriminate against you, you are covered under the third section of the definition, considered regarded as having a disability. Next slide. So another way to understand who is covered under the ADA definition of disability is if your body or brain works differently than most people. And that makes it harder or even impossible for you to do things like hear, see, speak, think, walk, or breathe. And again, these are just examples of things that are difficult to do or maybe impossible for you to do and are covered by the definition of disability. And remember, as we said earlier, some disabilities are visible or apparent, but most, the the vast majority of disabilities are not apparent or visible. Next slide. So disability looks different for everyone. So in the box on the left, the blue box, it says, what are some generalizations about specific disabilities you may have heard? So you can think about that. What are some generalizations about disability you've heard? And so what we want to talk to you about is, don't generalize that all people are the same or that people have a diagnosis. People with disabilities are not all covered by the medical model and don't need to be talked about as if they are people that are covered by the medical model. There are lots of models of disability. And what we really are talking to you about today, when we're talking about the ADA, is the civil rights model, the community model of disability. So don't generalize people by a quote unquote diagnosis. The truth is, if you've met one person with, say, epilepsy, you've met one person with epilepsy. If you've met one person who uses a wheelchair, you've met one person who uses a wheelchair. If you've met one person with a hearing disability, you've met one person with a hearing disability. Everyone is different. And that's why the ADA is a person by person, situation by situation, or case by case law. That's important to understand about the ADA. It can apply to people differently because people are different. Next slide. So in general, what is the ADA? What sections does it have? And what requirements does it have? So the ADA has 5 titles or sections. Title 1 is employment and covers all aspects of the employment process, from beginning and the interview process all the way through the job and after the job. Then the second title, or Title 2, is for state and local governments. Then public accommodations, which are private businesses or private nonprofits that are open to the public. Those are public accommodations. Those are covered by Title 3. And then telecommunications, which covers how you can use the phone if you are somebody with a hearing disability and somebody who can use 911 service as somebody with a hearing disability. And that's Title 4. And then Title 5 is miscellaneous, and that includes how do you enforce the ADA and what things apply and don't apply when you're talking about the ADA. So in general, the ADA says that any entity that is covered by one of those titles that I just talked about, employers, state or local governments, public accommodations, they must provide reasonable accommodations to applicants and employees with disabilities if you're in the employment area. They must provide accessible locations for their programs if they are state or local governments. They must all provide accessible websites. They must provide communication aids and services for people with hearing, speech, and/or vision disabilities. And they must provide reasonable modifications to some policies and procedures if they are state and local governments or public accommodations or private businesses, private nonprofits. And we're going to talk a little bit more about reasonable modifications here in a moment. Next slide. So let's start by covering briefly the ADA and employment rights. Next slide. So the ADA covers private employers with 15 or more employees and all state and local government employers, regardless of how many employees they have. But you can probably figure that most state, county, city employers are likely going to have 15 or more employees, okay? But the ADA does cover private employers with 15 or more employees and all state or local government employers. Now, state law may say that it covers employers even with fewer than 15 or more employees. So make sure that you know what your state law is as well, because state law can provide greater levels of civil rights, greater levels of accessibility, even than the ADA. So make sure that you know what your state law is for employment and everything else going forward. So the ADA also talks about that people with disabilities have to be treated the same as people without disabilities at all stages of work. When they're applying for jobs, when they're interviewing for jobs, when they're getting job training, for their pay rates and benefits. You cannot pay people with disabilities less or offer them different or lesser benefits. When they're getting promotions, when they need a leave or they have absences they need to take from the job, and even during the termination process, they should be treated the same as people without disabilities at all stages of work, except of course they have to have reasonable accommodations, and we're going to talk about that. Next slide. So, reasonable accommodations say that employers can help people with disabilities apply for and do their jobs. And employers are required to offer those reasonable accommodations unless they cause the employer an undue hardship, which is pretty hard for the employer to claim, pretty hard standard to meet. Okay, examples of reasonable accommodations. This again is not an exclusive list. It's just a number of examples. Could be having a different work schedule because maybe it's better for you to come in later or earlier. And if that doesn't change the job, then that's an accommodation your employer should consider offering. You may need a job coach so that you can learn how to do the job. Equipment that helps you do the job. I myself have some equipment that helps me with my job. Sign language interpreters, if you need that, and that's how you communicate. For meetings and one-on-one meetings or big staff meetings, you are going to need a sign language interpreter, and for other kinds of things on the job. Also, you may need your workstation in a different location or to make your workstation more accessible to you. There are many, many examples of what could be reasonable accommodations. Next slide. So now that we've talked a little bit about employment, let's talk about access to state and local government services and private businesses. Next slide. So state and local governments, as we learned earlier, they are covered by Title II of the ADA. And what the ADA requires for them is that a person with a disability must be able to use any building or outside area like a park and use any service run by state and local governments. So it's possible that an entire building could be inaccessible because it is so old and really difficult for that state or local government to make it accessible. However, any programs that are offered by that state or local government have to be accessible. So if you can't make that building accessible at all, you need to offer those services and programs at other buildings that are accessible. That's the concept of program accessibility for buildings that existed before the ADA. So examples of state and local government programs that might need to be made accessible are health centers and clinics run by state and local governments, public libraries, summer recreation programs or even summer camps, public housing, and websites. These are all examples of programs Programs can even include sidewalks and making sure that you have curb ramps on your sidewalks for the sidewalks that the city controls. So these are all examples of state and local government programs. Again, not an exclusive list, but some examples. Next slide. So state and local governments have to modify some policies or procedures if that's necessary so that they don't discriminate against people with disabilities. And they have to provide effective communication to people with hearing, vision, and or speech disabilities. So examples of what could be a reasonable modification of a policy or procedure could be allowing someone with diabetes to bring food into a library in case their blood sugar gets low, when usually you would not allow people to bring food into the library because you don't want people to make a mess in the library. Also, allowing a service animal when you do not allow pets. And we're going to talk more specifically about service animals in a moment. But allowing a service animal is a modification of your no pet policy. Also, you might move tables and chairs in a restaurant to create a path or an accessible route, as we call it in the ADA, for a person who uses a wheelchair so that they can come in to the entrance of the restaurant, get to that table, get to the bar if they want to go to the bar, get to the restroom, all the areas of the restaurant that they are entitled to access and everyone else gets to access. So you may need to move tables and chairs in order to create that accessible route for that person that uses a wheelchair. Next slide. So when entities are private, like a private nonprofit or a private business, but they are open to the public, they are considered public accommodations. And people with disabilities have the right to buy things from them, to enter and use their goods and services of a private business or a private nonprofit that are open to the public. And these are considered public accommodations covered by ADA Title III. So public accommodations have to remove accessibility barriers that are readily achievable. That basically means cheap and easy to remove in their buildings that were built before the ADA. Of course, a building that was built after the ADA, whether it's a private building or a state or local government building, that's already required to be completely accessible and meet the ADA standards. But for buildings that were built before the ADA, private businesses and private nonprofits have to remove accessibility barriers when it is readily achievable to remove those barriers. There is no grandfathering of any building built before the ADA. Even historic buildings have some requirements. And you can call us and contact us if you want to know more about that. Public accommodations also have to modify, as we said before, some policies or procedures and provide effective communication. So policy modifications and effective communication are required for state and local government and for private entities open to the public. So examples of public accommodations can be restaurants, stores, movie theaters, gyms, centers for independent living that are nonprofits, and health clinics and offices. Next slide. So it's accessible transportation. Public transportation has to be accessible to people with disabilities. And public transportation includes things like public buses, light rail, and commuter rail. And it also includes Amtrak. The Amtrak trains are covered under ADA Title II. That covers public transportation. Also, most private transportation has to be accessible to people with disabilities. That can include taxis, ride shares, hotel shuttles, and over-the-road buses like Greyhound. Okay? If they are not accessible, then they need to provide some sort of equivalent service that is accessible if they are considered public accommodations. And many private and public transportation providers now use apps, the apps that you may have on your phone or your tablet, to be able to ask for a rideshare ride or to be able to find out the schedule of the bus. If the transportation provider, whether they're public or private, uses an app, that app needs to be accessible, just like their website needs to be accessible. Next slide. Education. Public and private K through 12 schools, colleges, and universities have to meet the accessibility requirements of the ADA for their buildings and facilities like parking lots. So when we say a facility, we mean something like a parking lot or a park, something that's not a building, but it's still covered by the ADA. Okay, so public and private K through 12 schools, colleges, and universities have to meet accessibility requirements of the ADA and maybe state law requirements for their buildings and facilities. They also have to make reasonable modifications to some policies and procedures, again, when that's required so that they don't discriminate against people with disabilities. They must be given equal access to classes and exams for students with all types of disabilities that the ADA covers. And I'm going to get to your question in a little bit. I want to save questions till the end, but thank you for raising your hand. We will definitely get to you. And also, they must give effective communication to students with hearing, vision, and or speech disabilities. Also, public K through 12 schools and some private or charter schools also have to comply with the Individuals with Disabilities Education Act, or IDEA. We will not really be going into any details on the IDEA, but there are lots of resources that we can give you to find out more about that. Next slide. So, as I said earlier, when I talked about modifying policies and procedures, that you may have to modify your no pet policies to allow a service animal. We're going to talk more about service animals now. Next slide. So what about those service animals? Government agencies and public accommodations, which we learned earlier, are businesses and nonprofits, private nonprofits. They have to modify their no pet policies to allow service animals. So every entity covered by the ADA, whether it's a state or local government entity or a private business or a private nonprofit, they need to modify their no pet policies to allow service animals. And a service animal is now defined under the ADA as any dog. Now, you may have to allow a miniature horse as well. That is mentioned in the reasonable modification section of the ADA. But there are not many miniature horses out there. But it does mention that you may have to allow that if a miniature horse is individually trained to help a person with a disability. Okay, so a service animal is any dog or miniature horse individually trained to do a task that helps a person with any type of disability. It's not just people with physical disabilities, any type of disability. And there are two questions that you can ask the handler or the person that has the service animal. One, is the dog a service animal required because of a disability? And two, what work or task has the dog been trained to perform? It might be multiple tasks, but what work or task or tasks has the dog or miniature horse been trained to perform? The service animal must be housebroken and under control of the handler. And it must be on a leash or tether, or if the handler cannot use the leash or tether, or if that leash or tether interferes with what the animal does, the animal must be under strict voice or hand signal control by the handler. It cannot be running around. It cannot be barking. It cannot be growling. It cannot bite someone. That animal needs to be under strict control of the handler. Next slide. So, emotional support or comfort is not considered work or a task. And emotional support animals, also known as ESAs, are not service animals, are not individually trained, usually, may not be under control. They can be any animal, not just dogs or miniature horses. And they are allowed in housing with a medical professional letter. This is a situation where you can ask for a letter. You cannot ask for a letter for a service animal. You can only ask the two questions that we went over earlier for determining if an animal is a service animal. But emotional support animals are not considered service animals. They are not covered by the ADA. And you do not have to allow them in public places where there is a no pet policy. Next slide. So, a little bit more information for you. Next slide. What can I do to enforce my rights? We suggest that you start by contacting an advocacy organization like a Center for Independent Living, CIL, or the National Disability Rights Network, NDRN, center in your area to help you advocate for their rights, for your rights. There may be disability specific organizations like organizations for blind people, organizations for deaf and hard of hearing. There may be other organizations that do advocacy. So we suggest that you start there. And we do have a resource slide for how you can find your local independent living center or your local National Disability Rights Network, or also known as the PNA, or Protection and Advocacy Network. Also, you can file a complaint with the U.S. Department of Justice. You can do that in addition to asking for advocacy from an advocacy center. And the Department of Justice will forward your complaint, even if that complaint belongs with the Equal Employment Opportunity Commission, for example, or the U.S. Department of Education, because it's about education. If you file with the U.S. Department of Justice, they will forward the complaint to the right place. And for most complaints about the ADA, the Department of Justice is the right place for filing a complaint. Certainly about ADA Title II and Title III, non-education, non-transportation related claims. You can also file a complaint with your state human or civil rights department or your state attorney general. And finally, you can also, in addition to all of these things, you can also hire a lawyer and file a lawsuit. And your state bar association may have lawyer referrals for you. Next slide. So what about retaliation? What happens if you go and do advocacy to try to get your rights met, or if you file a lawsuit or file a complaint with a federal agency? Your employer cannot fire you for doing that. And they cannot punish you or fire you if you're an applicant or an employee for asking for your ADA rights. You are entitled to ask for those ADA rights. You may need to be careful in an employment situation that you are not too argumentative with your employer, but you certainly have the right to go through the interactive reasonable accommodation process with that employer. And that employer should be working with you on that. Also, you can ask government agencies, businesses, and nonprofits for your rights, and they cannot punish you for asking for those ADA rights. That would be considered retaliation that is not allowed under the ADA. Next slide. So here are some helpful resources. As I said earlier, we have given you some links to the ADA National Network, the U.S. Department of Justice, ADA website, which has lots of information on the ADA, including technical assistance materials. Also, the National Disability Rights Network, or Protection and Advocacy Network, as it was previously known, and the National Directory of Centers for Independent Living, who may be able to help you advocate for your rights. And our final slide. Oh, actually not quite. This is the penultimate slide. This is the almost last slide. So this is our future Lunch and Learn webinars in 2024. So this was just the first of 4 Lunch and Learn webinars that we'll be offering on the ADA in 2024. The next 3 are ADA Title III Business and Nonprofit Requirements on June 18th. We'll be going more deeply into what ADA Title III says about your rights to access businesses and nonprofits. Then on September 24th, we'll be talking about the ADA Title I and the employment requirements and your rights in employment. And finally, on December 3rd, we'll be talking about effective communication under the ADA. So we hope that you will register for and join us for all of these free webinars where we can go into a little bit more detail about all of these topics. Next slide. And this is how you can stay in touch with us at the Pacific ADA Center. You can contact us for technical assistance, toll free 1-800-949-4232. That's voice and relay. You can contact us by email, info at adapacific.org. We hope you will check out our website at adapacific.org. It has been newly redesigned. It is in plain language and has a lot of really helpful resources for you. And we hope you will join our email list. And we have the link there for joining our email list as well. And then we also hope that you will follow us on social media. And I have put what our names are or tags are on X or Twitter, Facebook and LinkedIn, and YouTube. Please do follow us on social media because we have a lot of interesting posts there all the time. So we encourage you to do that, as well as joining our email list and checking out our website and contacting us for technical assistance if you need us. Okay, and I see that Gabe has put the contact information also in the chat. And before we take questions, I just want to mention that we do hope that you will fill out an evaluation after this training and about all of the trainings that we provide. And I'm going to put that link in the chat right now for you. You will also receive an email after this webinar asking you to please fill out the evaluation. And we hope you do, because we really do want your feedback. We actually do read those evaluations. So please do that for us. Okay, one moment. I will get to the link for the evaluation here. There we go. Okay, so that is the link to the evaluation. And At this point, we're going to stop the recording so that we can take questions.